presentations on the topic called the case study on the contract law and the company law, which is known to be the corporation law as well. In our group, we are 5 members. First, Sujita, Elisha, Vikram, myself, Pema, and Suman. Now, we would like to proceed our presentations from the contract law. First of all, the definitions of contract. A contract is an agreement of understanding which the law of authorize. It might likewise be a characterized or a guarantee or the state of guarantee, which the court will uphold. A willful or conscious and lawful authoritative understanding between at least two equipped gatherings. Normally, the contracts are composed, however, might be spoken or suggested, and for the most part have to do with the business or deal or the rent for the tenure. In order to form a contract, there should be a following component. They are: first, offer and acceptance; second, intention to legally bound; then considerations, capacity to contract, genuine consent to the contract, and legality of contract. However, in this question, the John is 16 years of age, which is regarded as a minor, where a minor is a person who does not have the legal rights as similar to the fully grown-up persons, or simply it is defined as a person who does not reach the age of full majority, that is the age of 18 years, depending upon the countries like Japan, Taiwan, and Thailand. A minor is an individual who is under age of 20 years. But according to the law of New Zealand, the age of 20 years is regarded as a majority, and the countries like United States, United Kingdom, Italy, India, Mexico, Nepal, Canada, etc., they consider 18 years as the age of minor. When a minor reaches the legal age of majority, a person is responsible for their own actions, which includes the contract and agreement made by them between the parties with some considerations. In the sum of the cases, a contract can be valid, which is made by a minor, and cannot be void until a minor's minority of the contract, which pay the value of reasonable necessity, for example, food, lodging, clothing, medical attention, and educations.
Talking about the application of these rules, in this case, John is a minor who is under the age of 18, so he is not legally bound to contract to purchase tools by the law. People under the age of 18 do not have the same full contracting power of adults do. They still can make contracts, but there are special rules. In general, for a contract to be binding, a minor will have to affirm the contract that is agreed to bound by it after turning 18. A minor cannot be forced to affirm a contract, so there is a certain risk in contracting with a minor other than as described below. On the other hand, although many contracts cannot be enforced against a minor, the minor still can enforce the contract against the other party. Necessity product includes the products which are very important for daily life, such as fooding, clothing, medicines, and the products which are very important for overall life, such as training, apprenticeship, etc. A minor has the legitimate ability to contract for buy necessaries and to go into useful contract of administration, however, not for extravagances. Here are the tools for his plumbing apprenticeship is of necessaries goods, so he is bound by the contract to purchase the tools. A business contract of that sort of agreement that John has entered and where he has picked up benefit from the offers of app tools, shares, is legitimate and restricting except if denied. At the end of the day, contract is voidable at John's choice. For this situation, Jones wishes to end agreement. He is bound by it and he can uphold the agreement. Except if John disavows the agreement, can the outlet sue John to recuperate the cash owed by the bus tools.
Conclusion: John falls under minor, so he is prohibited to sign the contract, but in his case, plumbing apprenticeship is necessary for his well-being, so he is liable to make a valid contract. In addition, the minor can avoid the contract in the condition that the minor must return what they still have received from the party If the minor couldn't return what he or she received due to destroyed or damaged steel, the contract can be avoided. Or if he or she have nothing left, also the contract can be avoided. In case of John, the liquidator cannot sue the money from the John because he is a minor, and John can avoid the contract as his wish, and he has option to exit a contract as a desire, which is voiding a contract. So when someone chooses to enter into a contract with a minor, they have to take risks in the contract. Therefore, the liquidator cannot force John to pay the amount. The liquidator himself has to bear the loss as John being the minor. Next case is about corporate law, and I would like to start from the issue. The issue in this case is whether the company established on a low-cost budget with family members only should change its company type after 5 years period when its asset, income and the number of employees would have increased. In addition to this, there is another issue of using the company names Anzac Coffee that might be confronted for using the word Anzac for business purpose.
So the rules regarding the company name is: the proprietary limited company is regarded as a small business if it considers at least two from following: it has assets less than $12.5 million at the end of financial year, it has less than 50 employees at the end of the financial year, or it has gross operating revenue less than $25 million for the financial year. The rules regarding the name of a business: a company's name cannot be identical to an existing name. A company's name must show its legal status. No person may use the word Anzac or any word resembling it without the authority of the Ministry for Veterans Affairs. Anzac can be used for the name of businesses situated on a road, street, avenue or highway if it includes the word Anzac with the full address. The word Anzac may be used in the name of a street, road or park containing or near a memorial to the First or Second World War, or one should seek approval from the Ministries for Veterans Affairs. The applications of rules: when setting up a company, the primary step is to register the company name with Australian Securities and Investments Commissions (ASIC) and obtain an Australian company number. The first issue here is the type of company that should be registered. So the question is whether it is beneficial to register the company as a proprietary or a public company. Most small businesses prefer a proprietary company over public company. The most suitable company for the small business purposes is a proprietary company limited by shares. In this case, as the company is supposed to consist of the family members only, the better choice would be a proprietary limited company. Now, once we decide to choose proprietary company, the next deal will be whether the company will lie in a small company or the large proprietary company. The company lies in the small proprietary company as it satisfies all the three conditions to be a small proprietary company. Now the second issue is that over the time, when the assets increases to like $13 million and have estimated revenue of $26 million at the end of 5 years of period, the company will have 38 full-time equivalent employees. So the question is, does the company still remain in small proprietary company category? According to the criteria to be in small proprietary group, as stated in Corporation Act 2001, the company no longer satisfies the criteria as the assets is more than $12.5 million and the estimated revenue is also more than $25 million. Hence, it is mandatory to change the company status to large proprietary company from small proprietary company. One can also choose to change the public company if the company needs larger capital. Next issue in this case is if the company can be named after Anzac Coffee. Under protection of word Anzac Regulations 1921, to use word Anzac for the business purpose, one should take permission from the Ministry for Veterans Affairs. So Anzac Coffee name can be owned unless and until it is already registered by any other company.
In conclusion, the company can be registered as a small proprietary company. However, after 5 years period, as the company starts to grow, can be registered as the last proprietary company or the public company as of one's choice. Also, the company can be registered under the same Anzac Coffee unless it is already registered by seeking the permission from Minister for Veterans Affairs. And this is the end of our presentation. Thank you.